Staff, thank you for the opportunity to present this appeal. My name is Fred Townsend. I'm an attorney at Hudson Jones, Jayworth and Fisher, and I'm here with my clients, Don Lockwood of Lockwood Farms, LLC, and with Mr. Savage, Carlton Savage, the engineer on this plan. They're each obviously here not to make argument, but if there's a specific question that arises that I need some help, they could perhaps jump in. First, Mr. Vincent, your counterparts in Kent County, they serve on what? On the levy court.
Levy court.
So it is very common that they are mistaken for judges because they're on levy court. Once again, I'd like to begin with an acknowledgement that counsel's responsibilities in an appeal like this are not routine or easy. Sitting in judgment of your appointees is potentially awkward. And acting as an appellant body is also not a typical role for counsel, although it has not escaped my attention, and I think it was referred to earlier, that you've had a very recent experience serving in that role, and I think that's important. I'm also led to believe that there are just maybe 4 proceedings of this type that have occurred in recent memory, and that this subdivision denial may very well be the first denial of the Planning Commission of a subdivision plan in the history of Sussex County. So if I'm wrong about that, I don't think I'm very wrong, and I think that's a relevant consideration because that makes this decision important. I think the outcome of this is of interest to the public. It's of interest to both members of the community as well as the legal community, as well as the industry that's involved in development. Certainly, regardless of the extent to which there's important consequences related to this action, there are very serious consequences that are being felt by the applicant. The applicant's property now is in question. The value of it is in question. The degree to which it is suitable for development is questioned. His efforts to time the market and carrying costs or additional serious consequences that are felt by the applicant in this case. There's some potential irony here in that what is proposed on this 126-acre parcel is just a 25-lot subdivision. If it is the Planning Commission's intention not to permit standard subdivisions of this type or to favor cluster subdivisions, then of course what we're going to see or potentially see if another owner ends up with this property is the likelihood of an application for 3 to 4 times the number of units on a farm like this or on this particular farm. So I think that's of interest should be of interest to the council. So the standard of review is something that that's been referenced to you a couple of times recently with respect to the filings that have been made and also with respect to the recent appeal that you heard. The standard for you today is to consider whether the Planning Commission misapplied the law, and I would assert that they have in a significant way, and that the findings and conclusions that they reached are not the result of an orderly and logical review of the evidence. And it's my intention to show that the basis for the denial is not substantive. It's not based on substantive evidence. Excuse me. So I'm going to start with the law. I'm sorry about that. I don't want this to be terribly tedious, but the law in this case very heavily favors the applicant. There is Supreme Court law, there is case law from the Superior Court, and decisions that have been reached on this question that this group has followed and applied very recently. with respect to another controversial application. The first case I want to call to your attention is the Supreme Court case known as Tony Ashburn and Son versus the Kent County Regional Planning Commission. And in that case, the Supreme Court of Delaware held that the Planning Commission lacked the power to deny a subdivision plan that complied with all the applicable zoning and subdivision requirements. So obviously it's a Kent County case, but in that case, the Supreme Court had reversed the subdivision denial because the subdivision denial was based on plus review considerations that are offered by state agencies, not specific code criteria. They cited classroom availability, infrastructure, and then a list of health, safety, and welfare concerns. So there's another case, another very important case that I'm sure is very familiar to the lawyers in the room, and that's the Eastlake Partners case, which involved the city of Dover. And in that case, Judge Max Terry discussed the nature of health, safety, and welfare concerns and labeled them impact concerns. Impact concerns, and this is very important. Judge Terry said that impact concerns do not provide a basis for denial of a code-compliant plan because doing so would completely deny a use permitted under the zoning code. So that's obviously of great importance, and that's what's happened here. That's exactly what's happened here. These are impact concerns that have formed the basis of the Planning Commission's denial, not code considerations, not whether the property is suitable for subdivision. The next case I want to refer to is a case referred to as DeFrancesco versus Ellesmere. And that case held that landowners are entitled to rely on zoning to implement a permitted use, which is what we're faced with today in this application. And to hold otherwise subjects a purchaser of land to the future whim and caprice of the commission. So that quote may sound familiar to you, may ring familiar to you, because it was featured in your holding on this recent appeal that took place. That was word for word from the DeFrancesco versus Ellesmere case. And obviously the risk here is that if you apply these impact concerns, or if you make use of them such that you can deny applications outright, then you're on the path to arbitrary and ad hoc results. You're going to find in such an instance that the makeup, the present or then present makeup of the Planning Commission is going to dictate whether subdivision approvals are granted or denied. And that's the road to arbitrary land. And you don't want to be on that road. I want to go back quickly to Ashburn because the Ashburn case has another really important and very applicable holding within it that has a direct bearing on our code, a very direct bearing. It says that the court said that the very statute upon which the commission relied to deny the application provides only that the commission consider, in this case, state agency comments. So that language mirrors the language in 99C that's relied on. So the court said that the statute does not expressly or by implication give the commission unfettered discretion to deny an otherwise legally conforming subdivision. So your 99C language begins with the exact same phrase, and I'm going to quote, "The approval of a subdivision shall include consideration of the following," and then there are 17 considerations. It doesn't say that approval or denial of a subdivision will take into consideration the following 17 considerations. It says approval will involve consideration of the following. Of course, the developer doesn't grant approvals or consider approvals. That's the Planning Commission's authority. So this statute has been interpreted by the Supreme Court in Ashburn to say that you cannot imply from that language that an unfettered denial of an application can be based on those 17 considerations. In the other case, of course, it was the plus comments. Those are impact concerns. These 17 considerations are impact concerns. So I'm not here to argue that the Planning Commission is a rubber stamp. I'm certainly not taking that position. I'm oftentimes seated on the same side of the dais as Mr. Robertson is, and the Planning Commission's work is really important. But the Planning Commission is limited. It is not a legislative body. You're the legislative body. You establish the law. The Planning Commission cannot approve a subdivision without considering the 17 factors in 99C. But that, again, is not saying that the Planning Commission can use those factors to deny a code-compliant application. Now, Mr. Robertson might point out that the title of that ordinance includes the word denial in addition to the word approval, but nothing in the body of the ordinance speaks to denials. And if time allows, Mr. Morton chooses to, he can advise this group on the significance of the wording within the ordinance versus the wording of the title of a particular ordinance. And they're not to be confused with one another. The title is merely a convenience. So again, I think that the Planning Commission's responsibility here is very important, but it is not authorized to deny code-compliant applications, which are determined to be code-compliant prior to their preliminary hearing. And additionally, I guess it's potentially possible that the Planning Commission, during the course of a Planning Commission hearing, it could arise that certain facts come to light, in which case a determination could be made that the subdivision is, or that the land is not suitable for subdivision. But again, those 17 considerations, which were cited, are the basis of applying appropriate and reasonable conditions to a plan that is code compliant. And if that sounds surprising to you, I want you to remember that this is the first outright denial of a subdivision application in the history of Sussex County. So this is the first time the Planning Commission has ever relied on 99C to deny an application. If the Planning Commission had an unfettered right to deny applications while relying on 99C, ask yourself whether this 25-acre lot subdivision is perhaps the most objectionable subdivision in the history of the county. I don't think anyone here would come to that conclusion, not by a long shot. It is certainly not the most objectionable, not the most worthy of denial in the Planning Commission's history. But there's further support for this within your ordinance, this position I'm taking. And it's that Section 16A of Chapter 99 discusses circumstances under which subdivision is not appropriate. It refers to subdivision denials as a product of a finding that the land, not the development plan, not the subdivision plan, but that the land is unsuitable for subdivision due to flooding, for instance, improper drainage, adverse earth formations, utility easements, and other such things that pose a danger to health, safety, and welfare. A danger. And again, that would justify a determination that land is unsuitable, not that the plan is suboptimal, but that the land itself is not suitable for subdivision. And that was certainly not a finding of the Planning Commission. The Planning Commission doesn't say that this land is unsuitable. So the Planning Commission has essentially exceeded its authority in relying on these impact concerns or impact considerations in denying the application for Lockhaven. And then even in cases pursuant to your 16A section of Chapter 99, where land is determined to be unsuitable, which is not the case here, the code provides that if certain safeguards are designed into the project, that the subdivision approval can be awarded. So, denying a plan outright is really an extraordinary event in the history of Sussex County, and it's introducing a considerable amount of doubt as to what we can rely on when it comes to zoning. The benefits of zoning and the predictability of zoning. So I don't want to repeat myself, but this is very important, that the Delaware Supreme Court is saying that 99C style considerations, not directly, but they're saying this by implication, cannot serve as the basis for denying a subdivision plan. But they are to serve as the basis for imposing reasonable conditions. And as I said before, just look at the language of the ordinance and remember that the developer doesn't consider approvals, doesn't grant approvals. So this statute is designed to direct the attention of the Planning Commission to important factors. And it's designed to tell the public that these factors are what the Planning Commission will rely on and what they can speak to when it comes to granting and appropriately conditioning a subdivision. So reaching this conclusion actually really decides the case. If you agree with me about this, and I hope that you do, the case is essentially decided because the Planning Commission can't deny the application. They can only try and address these impact concerns through appropriate conditions. And, of course, that's not what happened. But Mr. Robertson's going to speak to what I'm sure the Planning Commission views as being their substantial evidence that the decision is the product of an orderly and logical review of the evidence, but it is not. The specifics, quickly, of the Lockhaven development is that it consists of 126 acres. It's proposing just 25 oversized lots. The minimum lot size is 1.6, and the average is 2.5 acres, and that's without considering one of the lots, which is oversized even by that standard. The site does have 28.7 acres of wetlands and 38.44 acres of woodlands. So what is unusual about this, or uncommon anyway, is that what's proposed is a standard subdivision, not a cluster subdivision. That's what the Planning Commission is most accustomed to seeing these days. And the reason cluster subdivisions are a favor in the development community is because they allow for a great deal more density than a standard subdivision. But this owner, my client, is not interested in maximizing the density on this property. It's in the record that he's considering making one of the lots his own homestead. So what we're talking about here is not quite a farmette-style development, but it's very unusual. And apparently it was confusing to the Planning Commission because the transcript of the proceedings below reveal that there were questions raised about whether wetlands can be subdivided under the law. And the answer was appropriately reached with the help of the chairman that subdivision of wetlands is not prohibited in a standard subdivision. It's prohibited in a cluster subdivision. So if the Planning Commission's holding is that it's inappropriate to subdivide wetlands, and if it can be interpreted as that, and I believe that it can, then what the Planning Commission has done is acted in a legislative manner. They have exceeded their authority. Their authority is ministerial with respect to conducting the hearing and partly quasi-judicial with respect to imposing conditions. So that's the Planning Commission's authority, and to by effect, outlaw or ban subdivision of wetlands. They've exceeded that authority, and they've entered into the realm that you all are familiar with as your legislative authority. So I'm going to take these considerations that were listed in the order that they were raised by Mr. Robertson. My goal here is to save about 5 minutes for myself for rebuttal. I've got a clock here that I can keep my eye on. So the first consideration that was raised was the availability of on-site septic. And the record shows that the feasibility study was performed, or a feasibility study was performed on the land where Lockhaven is proposed, and that the test revealed that the location could support 25 proposed lots, and that the soil tests were confirmed, and this is in the record, in the form of a September 3rd, 2021 email from DENREC, is that the test results in that feasibility study are valid today, because soils don't change over a period of 10 or 15 years. So the Planning Commission is saying that the age of the feasibility study is a justification for a reliance on the question whether on-site septic is available. Well, it's not. The substantial evidence that's in the record doesn't support that conclusion. DENREC has spoken, and that's really it. DENREC has spoken. The feasibility study has determined that 25 lots can be found on this lot, on this parcel. And anything else is conjecture. It's not substantive. That doesn't support a determination that the decision made by the Planning Commission in this matter is orderly and logical. What really matters is whether the feasibility study was done on this particular property, not whether it was done under the name of a different subdivision or one that has a slightly different lot configuration. The study tests all the soils, not just soils within the lots that are on the concept plan that they asked to receive in doing the study. And they're always done prior to final approval. They're always done prior to preliminary approval. In order to get to a preliminary approval, you've got to demonstrate that on-site septic, in a case like this, is available, and that's what has occurred. So we know that this is just a preliminary approval that's being sought, and that subdivision plans remain subject to being changed both during the preliminary approval process and prior to the final approval process. So the argument the Planning Commission is making that the feasibility study was done on a development that varies somewhat from what is currently proposed is not valid. It's not substantive, and it's not orderly and logical. And additionally, there is a reference to the potential in the Planning Commission's decision, to the potential for the need of mound systems on certain of the lots. Mound systems are not illegal. So we've got a code-compliant plan. The Supreme Court tells us that we can't rely on these impact concerns in denying a plan. If the Planning Commission's determination is that mound systems cannot be utilized in any case on a major subdivision, then they have exceeded their authority. They're entering into this realm of legislating, and of course that realm is reserved for this group. And we know that final site evaluations are done on each lot prior to the lot being sold. So the risk to the public is nil in this case. They know, whomever is a subsequent buyer is going to know what they can do and can't do. Another big feature here, or another big concern raised by the Planning Commission, is limited disturbance of woodlands and wetlands. And in this case, I'm going to call your attention again to these impact concerns, because how do we define what is a limited disturbance? How many trees are okay to remove? The code doesn't say trees can't be removed. So what is the Planning Commission's, how can the Planning Commission simply cite a very squishy standard such as preservation of woodlands and come to the conclusion that that this plan can't be approved? That introduces an incredible amount of arbitrary and ad hoc results into the application process. It makes it entirely unpredictable because you can't measure preservation of woodlands and make a determination that this either passes or fails that test. It's a consideration in granting an approval. And in fact, on this point, Mr. Savage, during his testimony, literally asked the Planning Commission if they wanted to see some additional safeguards made part of the restrictions. And that offer was not accepted. And also on this point, Mr. Robertson indicated that these site plans are oftentimes, and in every case actually, noted on the plan with language that requires the preservation of woodlands. The woodlands are preserved by the existence of the wetlands buffer, and additionally they are preserved and could be preserved by additional conditions, which would have been welcomed by the applicant but were not offered. There's an additional concern raised by the Planning Commission that the wetlands are not preserved or protected. That's a 99C consideration. How do you pass or fail that test? Well, the applicant has offered and proposed a wetlands buffer of 50 feet. So the wetlands are in fact protected. So is the next 50 feet from disturbance. And to hold that the wetlands are not protected is not supported by substantial evidence. DELDOT concerns were also raised. The DELDOT process is, of course, for DELDOT to weigh in on whether there's an objection to development on a particular site. And I see my time is running out. DELDOT has granted, in this case, a letter of no objection, and that really should end the analysis on this point. This particular proposal, in the letter of no objection, it was found that this proposed subdivision will have a minor impact on the land and on the neighboring roadways. So that's a minor impact. This minor impact cannot be the basis of a denial of a code-compliant plan. So to summarize, 99C considerations are not meant to establish whether a subdivision passes or fails. They are not imposed. 99C considerations are not imposed on the developer. They're imposed on the Planning Commission. They burden the Planning Commission to rely on them for the purpose of imposing reasonable conditions. That's their responsibility, and they've gone beyond that in this case. And for that reason, I ask you to reverse their decision, or alternatively, to remand it for appropriate considerations with instructions to condition reasonably this Lockhaven proposal. So with that, I'll try and reserve 30 seconds for myself. Or I would ask if there are any questions for me at this point.
I do, actually.
Yes, sir.
I want to ask if council had any questions or wanted to hold them till after the presentation. And
I want to verify a couple things. You're saying this is the first denial of this type in the history of Sussex County?
That's my understanding. The
Okay.
very first.
Very first. And I guess part of my question is, why didn't this come to council with simply because we've overridden planning and zoning decisions before, why didn't it just come with a negative, referral, and allow us to make the final call? Why wasn't that happening versus the appeal process?
Right. So Mr.
It's a subdivision.
Yes, this was subdivision.
It's a subdivision. We don't see subdivision.
Ever?
No. It was not a conditional use nor a change of zone.
No.
Right. So in those instances, that again is Planning Commission is authorized to make recommendations on legislative matters. As was pointed out by Mr. Moore, conditional uses and zoning matters, rezonings, those are legislative responsibilities. So you get, in those instances, a recommendation, and you follow or you don't follow. You have total discretion when it comes to those matters. Final discretion, it's where it should be. But in subdivision matters, the Planning Commission is performing an administrative function, not a legislative function. Once the planning staff says this is code compliant, and unless there's a determination made later on that it's not code compliant, well, then the Planning Commission's only authority then is to impose reasonable conditions, taking into account any number of important factors which are listed in 99C. I'm not saying they're to be dismissed, but they are the basis for reasonable conditions, not denial.
Last thing I wanted to verify, you said that they offered a 50-foot buffer. So what the total buffer would have been 100 feet?
Yes. So let me clarify. The plan imposes on itself, the plan that's proposed imposes a 50-foot buffer from the wetlands. And the Planning Commission has argued that the wetlands are not protected. The 50-foot buffer is from the wetlands. So the 50 feet within the buffer is not wetlands. That's whatever, is that uplands or something? It's not wetlands. So my point, it was not my point to suggest that there was a 100-foot buffer, but just that there's a 50-foot buffer that exists on lands that are not in the wetlands, that are adjoining the wetlands.
Okay. All right.
Anyone else? Thank you, sir.
Thank you, sir.